So according to it was only after the new government came.
For the first time, in a petition, your lordships may note of 14 July, sorry, 8th July, 8th July, yes, which they filed before this court. In that 8th July petition, they said 39 MLAs totally, and they referred to a disqualification petition of 27 June, which nobody was served, and they never referred to any of their earlier pleadings. Now, this whole exercise on 16 MLAs would never have taken your lordships so many days, unless you all wanted to revisit Nabam and all that. But on facts, if they had been fair and said there were only 16 MLAs disqualified at all times and not more, the situation was purely academic. And the reason is malafide. Why this division? The reason is malafide. You wanted to split the two. You were hoping that you would get back 23 of them and your majority would survive. That is why only 16 MLAs. But when the government fell, that necessity didn't arise. When that government fell, that rationale had gone. Now you wanted to topple the whole government. On this disqualification issue, a second major fault on the part of the speaker. He gives me 2 days to reply. Number one is very important. A little factual digression is necessary, but it is a little law and a little factual because this is very important. But this reveals malafide on the part of the speaker in the extreme. Sorry, deputy speaker. Incidentally, there was no speaker for 2 years in Maharashtra.
There was no speaker at all.
Yes.
The deputy.
Number one, within 7 days, please see Rule 73B. It said PDF 129 JC1. Sorry.
What does Rule 73B say?
Yes. Statute compilation.
15 days, right?
7 days.
7 days.
Okay, that's fine. We can go. But that's all I want to point out. Really, it's 7 days. But what is important is, whereas the Maharashtra Assembly rules may be subject to Article 212, which says irregularities of procedure can't be looked at by a court. Mere irregularities. If it's a serious irregularity, the latest judgment of Justice Khanvilkar's 3-judge bench says that if it involves a question of natural justice in another Maharashtra Assembly case, then it's escalated to the level of a constitutional provision which must be obeyed. And the violation would be 14, 21, etc. But as far as the disqualification rules are concerned, and when I talk about 7.3b at page 12, this is not part of the assembly rules. This is now part of the disqualification rules.
Page 10 of the
And these are framed under paragraph 8. And my submission is that these rules are mandatory and any breaches of them by a speaker stroke deputy speaker are not immune from judicial review as per other procedural regulations under 208. Whose effect are diluted by 212. Now, just 2 paragraphs of 2 different judgments. Actually, I've set out, but your lordships may just see Kyoto's judgment. PDF 129, judgments compilation 1.
You are referring to these Quixote and Shrimant to say that principles of natural justice is mandatory. There's no dispute on that. Take that point.
Not just that, it's a specific reference to the. I'll just read one paragraph, your lordships will see what I'm getting at.
Para.
Para 97 in Kyoto,
Page one.
page 129, PDF 129.
Para 97.
Yes. It's not just the rules pertaining to natural justice. Paragraph 8 rules are all immune from the dilution provided by Article 212. Because these are, I'll tell your lordship, the reasoning comes there. Please see that. That's why I want your lordship to just see it. The reason is contained in paragraph 96. That apart, even after 1986, when the 10th schedule was introduced, the Constitution did not evince any intention to invoke Article 122 or 212 in the conduct of resolution of disputes as to disqualification of members under Articles 191 and 200 and 102(1). The very deeming provision implies that that the proceedings of disqualification, the deeming provision says these shall be deemed to be proceedings of the House. The very deeming provision implies that the proceedings of disqualification are in fact not before the House, but only before the Speaker as a specially designated authority. The decision under paragraph 6(1) is not a decision of the House, nor is it subject to the approval of the House. The decision operates independently of the House. A deeming provision cannot by its creation transcend its own powers. There is therefore no immunity under Articles 122 and 212 from judicial scrutiny of the decision of the chairman, speaker or chairman exercising power under paragraph 6(1) of the 10th schedule. Now, my lord, 6(1) includes the whole gamut of procedure, starting with the petition for disqualification. The entire gamut of the procedural provision, 6(1), and your lordship may then just see 8.
Para 61, right?
It says, subject to the provisions of subparagraph 2 of this paragraph, the chairman or the speaker of a house may make rules for giving effect to the provisions of this schedule, and in particular, and without prejudice to the generality of the foregoing, such rules may provide for, and your lordships may kindly turn to D. D. The procedure for deciding any question referred to in subparagraph 1 of paragraph 6. So when my learned friends talk about the Supreme Court intervening with that notice period, which is prescribed, I'm talking about the 27 decision, which is prescribed under rules framed under 8, i.e. 7(3)(b), the Supreme Court was fully justified. The bench of that day was fully justified. Apart from the fact that it ill behoves a legislative assembly to say that rules framed by it under a constitutional provision can be blindly ignored by it. I mean, they are the legislators. If they set that precedent, God save the rest of the country. Now, my lord, even in the latest case of Shriman Patil, I'll just read it from my note, the relevant provision. Even the latest case of Shriman Patil, hello, that was the, I'm now at the bottom of page 12
Bottom.
on D. I'm on D. Even in the latest case of Shriman Patil, my lord, this was the, I believe, the Karnataka Assembly case, where time for a reply to a disqualification petition was contrary to the rules of the Karnataka Assembly, the court held in paragraph 190.7 at under. Our findings on allegations of not granting specific time in all the above cases are based on the unique facts and circumstances of the case. But actually, after Kyoto's case and the elevation of those rules under paragraph 8, there should never have been any leniency in time given to file a reply to a disqualification notice. You are affecting not only the MLA but his constituency. It should not be understood to mean that the speaker could cut short the hearing period. The speaker should give sufficient opportunity to a member before deciding a disqualification proceeding and ordinarily follow the time limit prescribed in the rules of the legislature. So well, an exception was carved out in that case, but now, my lord, on the one hand, a disqualification petition is given to us. The speaker ignores Nabam Rabia. 2, he gives me a 2-day instead of a 7-day period. 3, what happens? Now, my lord, kindly see. I am now on 13, and this is a very important aspect. While those disqualification proceedings are pending, everything is done to prevent me from coming for a hearing. Please see. Now, my lord, I would request your lordships, this is the prelude to my petition before this honorable court on the 27th. This is what actually happened. I did pray for staying of the disqualification proceedings, and in my respectful submission, even had a quia timet, my learned friend Mr. Kaul pointed that out, even if a quia timet injunction had been granted restraining me on restraining the speaker from pursuing the disqualification proceedings on the ground that a constitutional provision, i.e. 179C, was being ignored. Because Nabam Rabia was the law at that time. Right? Even if they had done it, which they didn't do, there would have been nothing wrong with it. What they actually did ultimately was only confine the reliefs granted to police protection, and I'll come to your lordships why, and the time period extension from 7 to 14, from 2 to 12 days. Now, my lord, your lordships will kindly see the threats that were given to me. First, your lordship will kindly see, and this is very important because I couldn't come. They prevented me from dealing with my disqualification application. First, they ignored the 1979C, they chucked it to the dustbin. Secondly, they gave me practically no time, 2 days. And then, kindly see the threats that were issued to me. So the first one your lordship may see is 24th June.
Not necessary to read the threats.
You've relied on para 97 of Kyoto. You have also distinguished.
But very important.
We take
That's
it
all
that
right.
it was compelling for you to come to
Yes,
the court.
but I'll summarize what those threats were. First of all, my lord, security to, I was out of Bombay. Security to my family members was withdrawn. Death threats were being given, security was withdrawn, and publicly there were pronouncements of the leaders of the Uddhav Thackeray faction that if I come back to Bombay, if I come back to Mumbai, my bodies would be sent straight to a crematorium. That's the nature of threats. In view of that, I had to move the Supreme Court for multifarious reliefs. Out of those, on the 27th, only 2 were granted. There were serious death threats. My lord, one of them, a gentleman called Tanaji Sawant, an MLA, I think he was the minister of the government when the government was united. His office was burnt. It was the most serious situation at that time. And kindly see the response. Now, I don't want to tread on the solicitor's province. But your lordship may just see the letter of the governor at that time. Because, my lord, this shows the kind of information that the government was always receiving, continuously receiving, which ultimately culminated in his decision to cause a flaw test. Page 306 PDF.
Sir, it was read and reread. That letter to the governor was read and reread. Correct? So we know that these are the things, correct? Earlier there is a threat and earlier there was a coalition government, there is a breach. Everything has been read, Mr.
No, this letter pertains to the governor saying the situation is extremely serious.
Correct, that we have.
Please give them security. Look, they're talking now about a speaker and a government that ignores a constitutional mandate. I just want to just see what is happening. The thread. You throw out the leader of the legislature party. He gives you a notice fearing disqualification under 179C. You ignore it on completely specious grounds. Then you serve me the next day. Next day, you serve me a disqualification petition for 16 MLAs. Divide and rule. When I get that disqualification petition, in the notice you say, reply within 2 days. Contrary to rules, mandatory rules. And finally, you prevent me from coming to Mumbai. I'm entitled to a hearing. You prevent me from coming to Mumbai with death threats and withdrawal of security to my wife and children and burn houses. Conduct of the speaker, therefore, needs to be, that's the only reason why, notwithstanding that the fact that the factual basis of this case doesn't warrant any legal relook at Navam Beria. Because as I said earlier, Navam Beria was never an issue because the notice was never ever acted upon. Notwithstanding that fact, restrictions circumscribing misuse of power by the speaker need to be imposed. And Justice Mishra's judgment in Navam Beria needs to be reaffirmed. So I'm not going into the governor's letter.
What else, Mr.?
Under Article 164(2), my learned friend talks about a very high constitutional principle. He elevates the entire conspectus of this case to the evil of defection. The evil of a speaker and a government hell-bent upon power is an even greater evil. But there's a constitutional principle, which the Lordship just look at G at page 14. The principle emanates from 164(2), which says that the Council of Ministers are collectively responsible to the Legislative Assembly of the state. Well, what does this mean in practice? It means that when the Council of Ministers collectively lose the support of the majority of the House, they have to step down. So, my lord, much higher than the evil of defection is the principle of majority rule in this country. That is paramount. And the principle of majority rule is to be found, there are judgments on 164(2), is to be found in 164(2). That when and that's why the governor is given the right to form a new government headed by that person, not headed by a political party, headed by that person who commands the majority in the House. And he has to ignore, says Rameshwar Prasad and Shivraj Chauhan, which my learned friend Mr. Kaul read out, he has to ignore the fact of any potential disqualification of those members who might support the new government. Now, my lord, at page 15, your lordships may note point 2, H, main heading H, Supreme Court refused to grant stay on floor test. And 2. Well, these two, I'm not going to read these petitions, but they say there are only, on 29 June, and they say that there are only 16 MLAs disqualified. That is the last date on which anything could have affected them. 29 June itself, the petition was for disqualification of 16 MLAs. As I said, the 16 MLAs issue came only on, and now till today we don't know the number of that petition. It was allegedly filed. It was allegedly filed before the deputy speaker. We do not know the disqualification petition number till today. It is placed before your lordships. What's the page? I'll just give your lordship the page. Never served upon us. But the contention is 39 MLAs all along. Now, just the last three points very briefly. At page 16, KL and M, sorry, J, K, and L. The flaw test was never held. Although there's some limit to causation in the law. To say that Mr. Uddhav Thackeray resigned because of all that went before is, my lord, stretching credulity to the nth degree. He resigned because he knew he had lost the majority. But, my lord, there has to be, this is too remote a cause in law for that to be a consequence of all that happened before. He voluntarily stepped out. Now, my lord, JKL, I'll just read it out quickly and then I conclude. The question of deemed disqualification. There is no such concept as a deemed disqualification. Disqualification has to be actual, and there is a mandated procedure for disqualification proceedings. My lord, I request your lordship to just indulge me and read Rule 7.7. Page. This is under the disqualification rules, not now under anything else, and not under the assembly rules.
Page 10.
7.7, your lordships were referred earlier. Sorry. The lordships were referred earlier to 7.3b, which was that notice period. Now, 7.7 is the rest of the procedure. Please have a look at it. And for the question of deemed disqualification. It's page 12 of the statute compilation volume.
Yes, sir.
This must be quite threatening.
Huh?
Our presence must be quite threatening.
Acha, you said presence.
Presence.
We have heard patience.
No.
We thought our patience.
Inquiry under sub-rule 4 shall be, so far as may be, the same as the procedure applicable for the determination by the committee of any question as to breach of privilege of the assembly by a member, and neither the speaker nor the committee shall come to any finding that a member has become subject to disqualification under the 10th schedule without affording a reasonable opportunity to such member to represent his case. There has to be a mandatory hearing in this matter. There cannot be a disqualification without a hearing. Therefore, to talk about a deemed disqualification in the absence of a hearing is to suggest this. Now, my lord, it is suggestive, my submission on this point. A deemed disqualification is suggestive of a contention that the reply of a delinquent MLA and the hearing which he has a right to before the speaker are both empty formalities. It further suggests that the speaker would be necessarily of predetermined mind and partisan bent. To deem disqualification, that means the hearing is an empty formality. Something which a litigant who claims to be upholding lofty ideals and unbiased procedure should be loath to canvass. Then, my lord, equally untenable is the contention of dating back of a disqualification. The judgments at both Rana and Patil are no authority for setting the clock back on all events that took place up to the date of the action which made an MLA liable for defection. A plain reading of those judgments, well, what Mr. Kaul has read them out, clearly reveal, see, for example, Rana's case in paragraph 34, that the speaker has to decide. That's all that Rana is authority for. The question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies a whip. It is really a decision ex post facto. The phrase ex post facto does not entail retrospective operation. The argument also completely ignores Articles 189(2) and 191(2) of the Constitution, both of which clearly indicate that an order of disqualification only had retrospective effect. Particularly important, my lords, is 191(2), which says he shall be disqualified when he is disqualified. It has only, disqualification only has prospective effect, not retrospective effect. And lastly, my lord, L, I've already taken this point, so I won't repeat it. But I am deeply grateful for a very patient hearing.